Can a limited liability partnership be incorporated for non-profitable purpose? Answer is no. A LLP can be formed only for carrying out lawful business with a view to earn a profit by associating two or more persons who shall subscribe their names to an incorporation document. What is the procedure to incorporate an LLP? The procedure to incorporate a LLP, see, first application for a digital signature. All designated partners of the proposed LLP shall obtain DPIN, Designated Partner Identification Number. So E-Form DIR 3 in order to obtain DIN or DPIN. In case already have a DIN, Director Identification Number, the same can be used as a DPIN. The application for allotment of DIN has to be made in Form DIR 3. The form shall be signed by company secretary in full-time employment of the company or by the managing director or CEO, CFO of existing company in which the applicant shall be appointed as a director. Then the name reservation, LLP run form, there is a limited liability partnership reserve unique name is filed for the reservation of the name of the proposed LLP, which shall be processed by the CRC, Central Registration Center, under non-STP mode. The name in the form shall be checked with the names of existing companies or LLPs. This precaution has to be taken care, and the registrar will approve the name only if the name is not undesirable in the opinion of the central government and does not resemble any existing partnership or LLP or any body corporate or a trademark. See, the form run LLP has to be accompanied with the fees as prescribed, which may be either approved or rejected by the registrar. Again, a resubmission of the form shall be allowed to be made within 15 days for rectifying the defects, if any. The total period generally for resubmission of document shall not exceed 30 days. There is a provision to provide two proposed names of the LLP in a single form. Then incorporation of LLP, the form used for incorporation of LLP is FILLIP, the form for incorporation of limited liability partnership, which shall be filed with the registrar. Now then the form will be integrated form. The fee as prescribed shall be paid. The form also provides for applying for allotment of DPIN. If an individual who is to be appointed as a designated partner does not have a DPIN or DIN, the form also provides the facility for applying of a DIN. Then the application for allotment of DPIN shall not be made by more than 5 individuals. The application for reservation may be made through FILLP. So there are two options available. So if the name that is applied under Rule 818 in the form of run LLP is approved, then this approved and reserved name shall be filled as the proposed name of the LLP. The limited liability partnership agreement. The limited liability LLP agreement governs the mutual rights and duties among the partners and between the LLP and its partners. It has to be filed in Form 3 online mode on MCA portal. Form 3 or LLP agreement has to be filed within 30 days from the date of the incorporation. It has to be printed on stamp paper. The value of stamp paper is different for every state. Then what does an incorporation document contain? The incorporation document contains, be in a form as may be prescribed, state the name of the LLP or limited liability partnership and state the proposed business of the limited liability partnership and state the address of the registered office of the LLP and state the name and address of each of the partners who are to be partners of the LLP on incorporation, and state the name and address of the persons who are to be designated partners of the LLP on the incorporation, and contains such other information concerning the proposed LLP as may be prescribed. See, what happens if the intending partner in a LLP tends to be a body corporate? Then according to Rule 12 of the LLP Act 2008, where the intending partner is a body corporate, then a copy of a resolution on the letterhead of such body corporate to become a partner in the proposed LLP has to be attached, and copy of the resolution or authorization of such body corporate also on letterhead mentioning the name and address of an individual nominated to act as a nominee or nominee and a designated partner on its behalf shall be attached. Then what happens if foreign nationals residing outside India or foreign body corporates registered outside India wants to register as a LLP? The answer is, when foreign nationals residing outside India or foreign body corporates registered outside India seeking to register a LLP in India, then along with all the documents that are required to be filed for incorporation, such additional documents shall be duly certified. The name, address and signature of the individual or nominee and designated partner of body corporate on the incorporation document, and proof of identity wherever required. And where are the register for LLPs maintained, containing the list of all LLPs and how it shall be. See, the register of LLPs are maintained in the office of registration, in which the name of the LLP shall be entered in order to which they are registered, and further LLP so registered shall be assigned a LLP identification number. This is LLP IN. That will be a consecutive series. How can a document be served to a LLP or partner or designated partner? A document may be served on a LLP or a partner or designated partner thereof by sending by post under certificate of posting, or by registered post, or through courier or electronic transmission. So which means a communication. So whether a LLP can declare an additional place for receiving communication from register? Yes, LLP can, beside its registered office, can declare an additional place of address for receiving communication from registrar in the manner as laid down in LLP agreement, and where there is no such provision in the LLP agreement, after obtaining consent from all the partners, it can be done. See, the intimation of such other address for service of document to LLP shall be given to the ROC in the form 12 along with the fee within 30 days of complying with the requirements as mentioned. Whether LLP can shift its registered office from one place to another? Yes. LLP can shift registered office from one place to another by the following the procedure as laid down in the LLP agreement. And where the LLP agreement does not provide such procedure, then consent of all partners shall be required for changing the place of the registered office of the LLP to another place. In case change of the registered office within the same state, then notice of the change must be filed with the registrar in form 15 within 30 days of the change. If the registered office being moved from one state to another, then the notice must be filed with the registrar within 15 days of the change in the form 15. See, what are the provisions relating to the shifting of registered office from one state to another state? See, the shifting of registered office from one state to another then the LLP shall follow the procedure as laid down in the LLP agreement to shift its registered office, and in the absence of such provision, obtain consent of all the partners to shift the registered office from one state to another state. And in addition to it, LLP shall obtain consent from its secured creditors. It shall publish a general notice not less than 21 days before filing any notice with the registrar, in a daily newspaper published in English and in the principal language of the district in which the registered office is situated, and circulating in that the district giving notice of the change of registered office, and shall file a notice in Form 15 with the registrar from where the LLP proposes to shift its registered office, with a copy thereof for the information to the registrar under whose jurisdiction the registered office is proposed to be shifted. Whether the provisions relating to shifting of registered office within the state but under a different jurisdiction of the registrar is similar to shifting from one state to another? Yes. The provisions relating to shifting of registered office from one place to another within the same state, from the jurisdiction of one registrar to another registrar, is similar to that of the shifting of one state to another. However, the only exception is that the LLP is not required to obtain consent from its secured creditor where the registered office is shifted within the same state. What is the penalty if the provisions for shifting of registered office is not followed? See, if the limited liability partnership contravenes any of such provision, the limited liability partnership and every partner shall be liable to a penalty of 500 rupee for each day during which the default continued, subject to a maximum of 50,000 rupees for the limited liability partnership and its every partner. What is the effect of registration? The LLP after getting registered will become capable of suing and being sued, acquiring, owning, holding and developing, disposing of property, whether movable or immovable, tangible or intangible, having a common seal if it decides to have one, and doing and suffering such other acts and things as bodies corporate may lawfully do and suffer. Can LLP be formed without using the word LLP as the last word of its name? Every LLP shall either have the word limited liability partnership or the acronym LLP as the last word of its name. No LLP shall be allowed to incorporate without using such words. What kind of names are not acceptable for registering LLP? LLP shall not be allowed to get registered with a name which is in the opinion of central government is undesirable or identical, too nearly resembles to that of any other LLP or a company or a registered trademark of any other person under the Trademark Act 1999. What is Form Run LLP? See, Form Run LLP is a web-based form that is available at MCA official website for filing of application for reservation of name of proposed LLP or name to which LLP proposes to change its name. What is the period of validity of the reserved name of proposed LLP or changed name? See, the name which has been approved by the registrar remains valid for a period of 3 months from the date of intimation by the registrar. If the proposed LLP is not incorporated within the said period, the name shall be lapsed and will be available for other applicants. Can a foreign LLP or a foreign company apply for the same name with which it is registered in the country of incorporation? Yes, a foreign LLP or a foreign company can apply for reserving its existing name by which it is registered in the country of regulation or incorporation by applying in a Form 25 to the registrar. Moreover, such reservation shall be valid for a period of 3 years from the date of intimation by the registrar, but which may be renewed on a fresh application. Under what circumstances The name for LLP shall not be reserved. See, if it includes any word or words which are offensive to any section of people, the proposed name is exact Hindi or English translation of the name of existing LLP in English or Hindi, as the case may be. If the proposed name has to close phonetic resemblance to the name of the LLP in existence, or example like JK LLP, then JAY KAY LLP, then it is not allowed. It includes the word cooperative or sahakari or equivalent of the word cooperative in the regional language of the country, then it is not allowed. See, it connotes, if it connotes the participation or patronage of the central or state government, unless the circumstances justify. See the example, a name may be deemed undesirable in certain context if it includes any of the words such as national, union, central, federal, republic, president, Rashtrapati, etc. These are the few examples. See, if the proposed name contains the word British India, then it is not allowed. If the proposed name implies association or connection with any embassy or consulate or of a foreign government which suggests a connection with the local authorities such as municipal, panchayat, ZP or any other body connected with the union or state government. And if it is different from the name or names existing limited liability partnership only to the extent of having the name of the place within brackets before the word LLP. For example, Indian Press, Delhi is in bracket LLP, should not be allowed in view of the existence of the LLP named an Indian Press LLP. So even if it is keeping in the bracket, so then it is not allowed. However, the name shall be reserved in case no objection certificate is granted by the registered LLP partnership or a company, as the case may be. It includes name of registered trademark unless the consent of the owner of the trademark has been produced. See, the proposed name is identical with or too nearly resembles the name of any of the LLP or company, then it is not allowed. If it is identical with or too nearly resembles the name of the LLP or a company in liquidation, or it is identical with too nearly resembles name of LLP or a company which is strike off up to period of 5 years, it is not allowed. It includes words like a bank, insurance, banking, venture capital, mutual fund, or business activity includes the words like a bank, insurance and banking, venture capital or mutual funds or such similar names without the approval of the regulatory authority is not allowed. Nevertheless, the approval of regulatory authority shall be obtained at the time of incorporation, at the time of application for incorporation or change of the name of existing LLP, as the case may be. See, the proposed name includes words like a French, British, German, etc. unless the partners satisfy that there is some form of collaboration and connection with the foreigners of that particular country or place, the name of which incorporated in the name. Otherwise, it is not allowed. See, if the proposed name of the LLP includes the words company secretary, chartered accountant or advocates or such similar words as indicative of the profession as a part of the proposed name, the same shall be allowed only after obtaining approval from the council governing such profession or such authority, as the case may be, nominated by the central government in this behalf. And moreover, see, the approval of a council governing the profession shall be obtained at the time of application for incorporation or change of the name of existing LLP, as the case may be. See, if the name of the proposed LLP includes the name of the registered trademark, can the name be allotted after producing consent from the owner of the registered trademark? If the consent received, then yes. What is the procedure for LLP or a company or a proprietor of the registered trademark under Trademark Act 1999 to request a direction from regional director regarding subsequently incorporated LLP with a similar or closely resembling the name? In these cases, no, the LLP or company or proprietor of the registered trademark which already has a name or trademark which is similar to or which is too nearly resembles the name or new name of LLP incorporated subsequently has to apply to RD, Regional Director, in Form 23 to give a direction to that LLP incorporated subsequently to change its name or to new name as the case may be. However, it is important to note that an application of the proprietor of a registered trademark shall be maintainable within a period of 3 years from the date of incorporation or registration or a change of the name of LLP under the LLP Act. And see, the application filed in Form 23 shall state LLP IN of Limited Liability Partnership or the SIN of the company or the registration number of any other entity as the case may be. The name with which the LLP or the company or any entity was incorporated or registered, name has to be written, and the grounds of the objection to the name of the LLP incorporated subsequently. These details has to be mentioned. See, what are the documents that need to be attached while filing the application as discussed? See, the person making the application shall attach a copy of the incorporation certificate of the LLP or the company or the registration certificate of the entity as the case may be. Under which circumstances can the central government direct LLP to change the name? LLP can be directed by the central government to change its name if through inadvertence or otherwise the LLP on its first registration or on its registration by a new body corporate, its registered name is registered by a name which is identical with or too resemble to that of any other LLP or a company, or the registered trademark of the proprietor of the trademark under the Trademark Act 1999 is likely to be mistaken for it, then on an application of such LLP partnership or proprietor referred above be respectively or the company, then the central government may direct such LLP to change its name or new name within a period of 3 months from the date of issue of such direction. Then what happens if the central government is satisfied that the name of LLP is not acceptable for registration or resembles a name already in existence? Then the central government may direct such LLP to change its name or new name within a period of 3 months from the date of issuance of such direction. See, what actions must LLP take after changing its name as per the directions of the central government? Then after changing its name or obtaining a new name as per the direction of the central government, then LLP shall within a period of 15 days from the date of such change give notice of the change to register along with the order of the central government, who shall carry out the necessary changes in the certificate of incorporation, and within 30 days of such change in the certificate of incorporation, such LLP shall change its name in LLP agreement also. See, what happens if LLP fails to comply with the direction given by the central government regarding the change of its name? If LLP fails to comply with the direction given by the central government, then the consequences the central government will allot a new name as follows to the LLP in accordance with the Rule 19A. Then thereafter the registrar will update the register of LLP with the new name replacing the old name, and the fresh certificate of incorporation will be issued by the registrar rectifying the LLP's new name. The LLP is required to use the new name thereafter as per the fresh certificate of incorporation. The LLP shall mention in brackets the statement order of the regional director not complied under section 17 of the LLP Act 2018 below the name of the LLP on its invoices, official correspondence and publication till such time the LLP changes its name subsequently in accordance with the section 19. Whether the central government can change the name of the LLP, even if LLP 5 is pending for disposal at the expiry of 3 months from the date of issuance of direction by RD? No. If LLP number, form number 5 filed by the LLP is pending for disposal at the expiry of 3 months from the date of issue of direction by the RD, the central government shall not allot new name to the LLP unless the said E-form is subsequently rejected. See, is an LLP allowed to choose a different name after central government has allotted a name to it? Yes. LLP has an option to change the name after it has been allotted one by central government, provided it adheres to the provisions outlined in section 16 of LLP Act. How can a registered name under LLP be further changed? See, LLP may change its registered name by following the procedure as laid down in the LLP agreement, where the LLP agreement does not provide such procedure, then consent of all the partners is required for change of the LLP, and the name is to be reserved by the LLP by filing run LLP. Once the name is reserved and approved by ROC, then LLP is required to file a notice of change of name with ROC in Form 5 along with the application fee within 30 days of complying with the requirements as sub rule 21. So upon register being satisfied that the change of the name is the one as reserved by the LLP, then he shall issue a fresh certificate of incorporation in the new name, and the changed name shall be effective from the date of such certificate. Then what is the fine for improper use of the words LLP or LLP? If any person or persons carry on business under any name or title of which the words LLP or LLP or any contraction or imitation thereof is or the last word or words that a person or each of the persons shall, unless duly incorporated as a LLP, if they use, be punishable with a fine which shall not be less than 50,000 rupees but which may extend to 5 lakh rupees. Then what are the vitals to be published on the invoices, official correspondence and publications of the LLP? Every LLP shall ensure that it invoices, official correspondence and publications where the name, address of a registered office and the registration number of the LLP and a statement that is registered with the LLP. Further, for the LLP whose name has been changed under 17(3) of the LLP Act, that is allotment of new name by the order of the central government, shall mention in the brackets the statement order of the RD not complied, so under section 17 of the LLP Act, below the name of the LLP on its invoices, official correspondence and publications till such time the LLP changes its name subsequently in accordance with the section 19. Then what is the penalty imposed if LLP does not publish its vitals on the invoices, official correspondence and publications? Yes, in such case LLP shall be liable to a penalty of 10,000 rupees. Then how can a person become a partner of LLP? See, a person who subscribed their names to the incorporation document at the time of incorporation of LLP shall be the partner of LLP, and any other person may become a partner of LLP by and in accordance with the LLP agreement. See how the mutual rights and duties of the partners intersect, and those of partners and LLPs would be governed. See, the mutual rights and duties of the partners intersect, and those of the LLP and its partners shall be governed by the agreement between the partners or between LLP and the partners. This agreement would be known as LLP agreement. See, whether LLP agreement would be mandatory for LLPs as per the provisions of LLP Act. In the absence of agreement as to any matter, the mutual rights and liabilities shall be provided for under first schedule to the Act. Therefore, in case any LLP proposed to exclude provisions of the requirements of the Schedule 1 of the Act, it would have to enter into LLP agreement specifically excluding the applicability of any or paragraphs of the first schedule. So we have to follow the Act. whether an agreement in writing made before the incorporation of LLP will be binding on the partners of the LLP. Yes, an agreement in writing made before the incorporation of LLP between the persons who subscribe their names to the incorporation document may impose an obligation on the LLP if such agreement is ratified by all the partners immediately after incorporation and the same is filed with the registrar in Form 3 within 30 days of incorporation of the LLP along with the fees. So ratification. So how will the mutual rights and duties of the partners and the LLP be governed in case of absence of agreement in any matter? See, if there is absence of agreement to any matter, mutual rights and duties of the partners and those of the partners and the LLP shall be determined by the provisions relating to the matters as are set out in the first schedule of the Act. See, within how many days of the incorporation of LLP has to be filed its LLP agreement? See, within 30 days. How shall the changes in LLP agreement be intimated to the registrar? See, any change in the LLP agreement shall be intimated within 30 days by filing a Form 3. How can a person cease to be a partner from the LLP agreement? See, an existing partner may cease to be a partner in LLP in accordance with the agreement with the other partners, or in the absence of such agreement by giving notice of not less than 30 days to the other partners of his intention to resign as a partner. Further, LLP shall in turn inform ROC about the cessation of the partnership interest by filing a Form 4. Under what circumstances can a person cease to be a partner of an LLP? So suppose a person shall cease to be a partner of LLP on his death or dissolution of the LLP, or if he is declared to be unsound mind by a competent court, or if he is applied to be adjudged as an insolvent or declared as insolvent. See, what are the responsibilities of an LLP towards the former partner? See, where a former partner of LLP ceases to be a partner unless otherwise provided in the LLP agreement, the former partner or a person entitled to his share in consequence of death or insolvency of the partner shall be entitled to receive from the LLP an amount equal to the capital contribution of the former partner actually made to the LLP and his right to share in the accumulated profit of the LLP. Then what are the obligations of a person who has ceased to be a partner in the former partner of a LLP? See, the former partner shall be responsible for any obligation to the LLP or to the partners or to any other person which he incurred while being a partner. Further, the former partner or a person entitled to his share in a consequence of his death or insolvency of the former partner shall not have any right to interfere in the management of the LLP. Then what shall be done if a partner of an LLP changes his name and address? See, every partner who changes his name and address shall inform the LLP within a period of 15 days, such form in Form 6. Further, LLP shall file a notice with the registrar in Form 4 within 30 days of such change. What are the important points that the notice to the registrar specifies with regard to the change of the name of the address of the partner or cessation of the partner in LLP? The notice filed with the ROC shall be in such form and accompanied such fee as may be prescribed and shall be signed by the designated partner of the LLP and authenticated in a manner as may be prescribed. And if it relates to an incoming partner, shall contain a statement by such partner that he consents to becoming a partner and signed by him and authenticated in the manner as may be prescribed. Consent is a mandatory. Then what are the consequences if the provision for filing notice to the ROC within a period of 30 days is not followed for the cessation or change in the name or address of the partner? If the LLP contravenes such provision, the LLP and every designated partner of the LLP shall be liable a penalty of 10,000 rupees. Then what are the consequences? If the partner does not inform the LLP regarding the change of his address, so if any partner contravenes such provision, then the partner shall be liable to a penalty of 10,000 rupees. Can a partner himself file the notice with the ROC? See, yes, any person who ceases to be a partner of LLP may himself file with the registrar the notice if he has a reasonable cause to believe that LLP may not file notice with the registrar, and in case of any such notice filed by a partner, then the registrar shall obtain a confirmation to the effect from the LLP unless LLP has also filed such notice. Further, if no confirmation is given by the LLP within 15 days, then the registrar shall register the notice made by a person ceasing to be a partner. Can a partner to act as an agent? Yes, every partner of LLP is, for the purpose of the business of the LLP, is the agent of the LLP, but not of other partners. Under what circumstances, if LLP is not responsible for acts of the partners? See, an LLP shall not be responsible for anything done by a partner in dealing with a person if the partner in fact has no authority to act for the LLP in doing particular act. If there is no authority and the person knows that he has no authority or does not know or believe him to be a partner of the LLP, then these circumstances. Then under what circumstances the LLP will be responsible for the act of the partner? Then the LLP liable if the partner of the LLP is liable to any person as a result of a wrongful act or omission on his part in the course of the business, during the course of the business of the LLP or with the authority, then LLP is liable. Further, in case of an obligation of the LLP, whether arising in contract or otherwise, shall be solely the obligation of LLP, where the liability shall be met out of the property of the LLP. What is the extent of liability of the partner under the LLP Act? See, the extent of liability under the LLP Act is a partner is not personally liable, directly or indirectly, for an obligation of LLP, whether arising in contract or otherwise, solely by a reason of being a partner of the LLP. However, this shall not affect the personal liability of the partner for his own wrongful act or omission. A partner shall not be personally liable for the wrongful act or omission of any other partner of the LLP. Hope you are clear. See, who is known as a partner by holding out? The answer is a partner, by holding out is a person who is actually not a partner in the LLP, but by words spoken or written or by conduct represents himself or knowingly permits himself to be represented as a partner in the LLP. Got it? No, actually he is not a partner. Any such partner is liable to any person who has faith on any such representation given credit to the LLP, whether the person representing himself or represented to be a partner does or does not know that the representation has reached to the person so giving credit. However, any credit is received by LLP as a result of such representation, the LLP shall be liable to the extent of credit received by it. Then what is the consequences of conducting an event of an act carried out by a LLP or any of its partners with intent to defraud creditors of the LLP or any other person for, see, this is for the purpose of fraudulent activity. See, in such case, then every person who was knowingly a party to the carrying out on the business in the manner aforesaid shall be punishable with the imprisonment for a term which may be extended to 5 years, and with a fine which shall not be less than 50,000 rupees but which may extend to 5 lakh. Further, if any criminal proceeding arise, then the LLP and if any such partner or designated partner or employee shall be liable to pay compensation to any person who has suffered any loss or damage by reason of such conduct. Also, if such partner or designated partner or employee has acted fraudulently without knowledge of the LLP, then LLP shall not be liable. What do you mean by the term whistleblowing in LLP? See, the term suggests that the court or tribunal may reduce or waive any penalty leviable against any partner or employee of LLP under two conditions: that such partner or employee LLP has provided useful information during the investigation of such LLP, or when any information given by any partner or employee, whether or not during investigation, leads to LLP or any partner or employee, such LLP being convicted under the act or any other act. So it should be noted that no partner or employee of any LLP may be discharged, demoted, suspended, threatened, harassed, or in any other manner discriminated against the terms and conditions of this LLP or employment merely because of his providing information or causing information to be provided. See, what benefits does the partner or employee of LLP gets after being acted as a whistleblower? In the event of being acted as a whistleblower, the partner or employee of LLP cannot be discharged or suspended or threatened or harassed or in any other manner discriminated against the terms and conditions of his LLP or employment merely because of his providing information or causing information to be provided pursuant to the provisions of Section 31 of 2008. Hope you are clear. Thank you.